Good afternoon, ladies and gentlemen. My name is Chanyne Cunningham. I work for Legal Aid Service of Collier County, and we're here today to discuss Chapter 7 bankruptcy. And the title of our presentation today is, how does it work anyway? What do you need to do in order to file a Chapter 7? What is bankruptcy all about? That kind of thing. So here we go. The first thing that I think you need to know about this is I'm going to have a disclaimer. I am a lawyer with Legal Aid Service of Collier County. Like I said, I'm providing you with general information about a Chapter 7 bankruptcy process. Please do not interpret this information as legal advice. The information I am providing is very general in nature and is for informational purposes only. If you decide that bankruptcy is something that might help you, please consult a lawyer who will provide you with legal advice. I am an attorney, but if you decide that bankruptcy is something that might help you, please consult a lawyer and attorney who can provide you with legal advice based on your specific circumstances. Anything I say today is a general information, and it may not apply necessarily to you, or there may be other things that I can't tell you because I don't know all the specifics. I am a lawyer. I'm not necessarily your lawyer unless I agree to represent you and sign a retainer agreement with Legal Aid. And just because if I were to answer any questions during the presentation, it doesn't create any type of relationship between us. Now that that's out of the way, let's move on to the heart of the matter here. Bankruptcy, and we're going to talk about the basics. Okay, what is bankruptcy? Bankruptcy is a legal process by which people or corporations or businesses who cannot pay their debts can receive relief from the creditors. Bankruptcy allows people to get a fresh start. It kind of wipes the slate clean and allows them to basically, it's a reset. Bankruptcy also allows some creditors who would never have a chance of collecting any money from someone who owes to actually, maybe collect something back. It just depends on what the person has and what the circumstances are. Bankruptcy is a federal issue. It's handled in the federal court system. And our federal court happens to be in Fort Myers. The bankruptcy system is overseen by a program called the United States Trustee Program, and that program is run by the Department of Justice. So that should give you a little pause. It's the Department of Justice, where the FBI is and things like that. The United States Trustee Program, one of their jobs is to appoint people in different localities to a position called trustee. The trustee is actually a person who administers a bankruptcy case, and they are basically one of the only people you would normally meet with, especially in a Chapter 7. There is little to no contact with judges in this unless there's some kind of objection filed by a creditor or the trustee to something in your case. The bankruptcy process is started by filing what's called a bankruptcy petition. People most of the time file what's called a voluntary petition, which is you're requesting to the court system for relief, and you need help with your debts, and you want to get a fresh start. There is also a possibility that creditors could file a bankruptcy petition, an involuntary petition. But most of the time, that's something that might happen to a business, not necessarily a person, and we're mainly here talking about persons. So the petition has information about you. It has information about your debts, a little bit of your financial history, your income, things that are related generally to financial circumstances. Now, there are many types of bankruptcy, at least 6 that I can think of right off the top of my head. The first of which is a Chapter 7 bankruptcy, and it's often called a liquidation bankruptcy, although it's kind of a misnomer for most people. for those with the Chapter 7 is for those with lower income. They have few or no assets. It allows you to wipe out your unsecured debts, and you may not have to pay anything back at all to your unsecured creditors. Secured creditors there's two types of creditors, secured and unsecured. Secured creditors are people that have something that they can take back if you don't pay. So like your car or a house or something like that, those are secured loans. And those you have to deal with by either paying or giving the property back. I mean, there's not really an option. You can get out of a secured loan in bankruptcy by giving up the property and not you want the money anymore. But okay, I'm diverging a little bit here. The next type is a Chapter 11 bankruptcy, and that's commonly known as a reorganization bankruptcy, where what it is it's mostly for corporations, but it can be for people with a lot of assets, personal debt, and has a lot of personal assets. Basically, what it does is a reorganization. It allows most companies to cut their costs and find ways to increase profits, and allows them to become, or to at least attempt to become, viable again. We've seen a lot of major corporations do it, in the last couple of years, but sometimes it works and sometimes it doesn't, and just depends. So the last type I'm going to talk about now is a Chapter 13 bankruptcy. It's a payment plan. It's basically a payment plan where you're trying to repay your creditors over time. And most of the time, this is a 3 to 5 year plan. And it requires that you have a consistent income level. You have a consistent income, I should say. In Chapter 7, there is a restriction on how much money you can earn. So in Chapter 13, there is no earning limit. Anyone can file, and it can allow you to keep some property that you might not be able to keep in a Chapter 7. On the right-hand side of the slide, there is a couple other numbers, 9, 12, 15. Those are also types of bankruptcy. 9 is for municipalities or states or, political organization like that, governmental organization. 12 is much like a 13, but it only applies to fishermen and farmers. And 15 would be someone with assets in like another country and the United States. It can be a corporation or an individual, but they're applying basically in our country to protect their assets while they have bankruptcy proceedings going on in probably another country also. So those are the basics of the 3 types of bankruptcy. Now, like I said, you have to qualify to be for a Chapter 7. So who can qualify? Chapter 7 has a maximum income limit, and basically it's based on 2 factors. It's your family size and the median income of the area or the state that you live in. So we happen to live in Florida, or at least most of our clients do. So here is a little chart on the right here, basically showing how much you can earn if you are a single person. You go across, and basically if you earn more than $52,534 a year as a single person, you're probably not going to qualify for a Chapter 7. Now, there are some things that you can wiggle around and maybe get you under that number, but generally that's the limit. And as you see, it goes up as your household size grows. So at 4-person household, you're looking at $84,165, or you can make $7,000 a month. Those numbers seem really big, but it's amazing how little that money can actually be if you have that many people in your house. So anything beyond 4 people, you would just add $9,000 to the number up here, the four, of the four-person household, and that's $9,000, and it equates to $700 a month if you're looking at it monthly income. So instead of, for five people, it would be, 93,165 and 77,664 dollars if you're doing it on a monthly basis. All right, so there is no maximum amount of or minimum amount of debt that you have to qualify for a Chapter 7. I say that only because in other bankruptcies, like in a Chapter 13, you do have a limit. Your unsecured debt can only be $419,000 and 149,275. 149,275. 419,275. Gotta get it right. But your secured debt is also limited. So there are limits in other bankruptcies, but not Chapter 7. I do have to say though, if you have extremely high debt and you do not have assets to back that up, if you have, $1 million in debt and you have nothing that you own, it's going to raise a red flag. And the trustee's office, the United States Trustee's office, is probably going to look at your case. It's not saying there's anything wrong, but it's just saying that there's something there to look at. You do not need to be a U.S. citizen to file for bankruptcy. You are required to have a Social Security number or an individual taxpayer identification number, which is ITIN. The only thing I would warn, and it's a little bit always in flux with the immigration laws right now, that filing bankruptcy could affect an immigration status. So you need to could probably consult an immigration attorney as well as a bankruptcy attorney. If you're, I would consult the immigration attorney first just to see what their opinion is on how filing a bankruptcy could affect you. So with that said, how do I file a bankruptcy? How do you do it? What's the process? I'm going to tell you, you do not need an attorney to file a bankruptcy, but most people are not going to be able to navigate this minefield without one. Bankruptcy is a very technical area of law, and it requires some specialized knowledge to navigate smoothly. I've seen people do it themselves. I don't know what their outcomes always are, but I can tell you that it's so much easier with an attorney. So I suggest finding an experienced bankruptcy attorney. On the left there's a little sign. I don't know if you can read it, but it's like bankruptcy $399, call this number. I happen to have been to Miami and I've seen these all over the place, that kind of thing. They're not attorneys for the most part. They're what are called petition preparation people, and they're not allowed to give you legal advice. And I'm not sure that what kind of how good a job they will do. So these $399 bankruptcy signs are a little bit crazy. Typically, if you're going to hire an attorney, a typical attorney's fees for a Chapter 7 bankruptcy are usually in our area in Naples, Florida, Collier County, somewhere between $1,000 and $2,500 for a case. Obviously, whoever you talk to, it may vary, and may vary in other locations too. So, but around here, that's typically what I think you would find an attorney would pay. Most attorneys will require, if not all, most will require the entire fee up front before filing the case. Legal Aid does have an attorney who accepts clients for Chapter 7 bankruptcy cases. That's me. We also have the ability to place some cases with private attorneys who are willing to take cases on a pro bono or free basis. It's very, the number of people we can place that way is limited by the number of attorneys who are willing to donate that time and and willing to take those cases. So in either way, in either circumstance, there are financial qualifications that you would have to that you would have to meet in order to be a legal aid client, or even to receive the pro bono attorney through legal aid. Once you've found your attorney, you'll meet with them and you'll discuss your individual circumstances. Everybody is different. There's always some little nuance or something that special that makes your case your case. And everyone has different problems and everyone has different reasons why they got to the point of bankruptcy. And when you meet with the attorney, there's going to be a lot of questions, and the questions are going to be concerning the issues that the attorney needs to flesh out. Your income, what are you making? Your assets, what do you own? What property do you have? What, your debt, who do you owe? What do you owe? How much? Is there, why? Any of your recent financial transactions? Have you transferred property? Have you given away any property? Have you paid back any of your friends or relatives within the last year instead of paying other people? Because that's frowned upon. You can't take care of your friends while your other creditors go empty. You'll likely be given homework. The attorney is going to request that you fill out a questionnaire. It's going to be quite lengthy. It's going to discuss basically all of the stuff that I just talked about and more. And it's important that you fill it out as best as you can with as much information and be truthful, because it's basic. It's going to be the basis of your bankruptcy petition. Sometimes, our questionnaire at Legal Aid is approximately 52 to 53 pages of information that we request. Not all of the information is pertinent. Some of it, is just there because the information has been necessary for some client in the past, and obviously the questionnaire then didn't have it, so we added it, or so we have we try to get as much information as possible because we're never quite sure, what we might need. And the next thing is you're going, sometimes some attorneys require a lot of documentation before they'll meet with you. Some of them will give you the questionnaire and then, tell you, fill this out and bring me these documents, but they're going to need a bunch of documents. What paperwork are you going to need to provide to your bankruptcy attorney? Well, you're going to need to do the questionnaire and give it back. And you're going to need to provide documents that verify the information like I was just talking about in your petition. And so that the attorney can base, have a good basis. The documents include things like pay stubs or evidence of income for the last 6 months. And if you have a spouse, you're also going to need your spouse's income for that same period. Even when you file bankruptcy, you have the option of filing a single. So even if you're married, you can file by yourself, or if you're married and you both have debt and you want to both file, you can both file, and you'll have a joint case. But even if only one spouse files, we still need information on the other spouse. It's required under the bankruptcy law. Although the other spouse won't be included in the bankruptcy, they require information about the whole household income and whole household earnings and things. Federal and state tax returns for the last 2 years are going to be needed. They're going to require you to provide bank statements for all accounts between you and your spouse for the last six months, probably. The number of months may vary depending on the attorney. A good number to look at is 6 months. Some may say 3 months. Other documents you're going to need: copies of home ownership documents like your deed, your mortgage statement showing what you owe and what you pay. It's possible they may ask you for your last property tax bill, information if you've sold a house in the last 10 years. They may ask you for insurance policy information. And it's possible, depending on the case, they could ask you to, if you've had an appraisal done on the property in the recent months, they might ask you for a copy of the appraisal. And if you don't own if you don't own a home, but you lease an apartment or a home, you need to provide a copy of your lease if you have a written lease. Continuing on, they may ask you for, if you have stocks or bonds, they may ask you for copies of that. Information on bank accounts that you've closed in the last year. Copies of, a registration or a title to your vehicle, depending on if you own it or you're still paying on it. They may ask you for insurance information. They're going to probably ask you for a loan or a lease statement that shows, what you owe and what you're paying on the vehicle. And possibly they might ask you for an appraisal of the vehicle, so they know what the value is. If you have a 401k, a pension, or retirement account, that's very likely you're going to need to provide statements on that. If you have a child and you have an education IRA, or you are in the state tuition payment program, prepaid program, that they're going to want statements of that. If you have life insurance policies, they may ask you for copies of the policy or the front page. Current student loan statements, documents regarding workman's comp or a personal injury claim if you have one of those pending. Copies of any lawsuits or garnishments, closure actions, anyone suing you. They're going to want to see, something regarding the case, and also any judgments against you. If someone has sued you and it's already gone through and they have a judgment, they're going to want to see that because we need to list them as a creditor. If you've recently been divorced within the last, couple of years, and either the final judgment, divorce decree, some type of property settlement, they're going to want to see that. If you have a support order, they're going to ask you for any unpaid bills that you can find, including attorney letters from creditor, from places, or collection letters, collection notices, any old, any medical bills you have outstanding. They may ask you for a copy of your credit report. I always try to get copies of 2 different credit reports. There's 3 companies out there, and I noticed that despite the fact that it's your credit report, sometimes things go on one credit report and don't make it to the other. So I typically like to look at 2. If you have a power of attorney over somebody or someone, they may ask for a copy of that. There may be some circumstances where a person wants to file a bankruptcy for someone they have a power of attorney over, and it's a little more complicated, but we would obviously need that document. If you are self-employed, the attorney's probably going to ask you for what's called a profit and loss statement. It's basically your income and expenses for a period of the last 6 months, at least, prior to the filing of, prior to when you expect to file bankruptcy. And they'll also ask you for bank statements for your business. And then, last but not least, anything else they ask you for, you need to provide them. They're asking you for a reason. It's not just, to bother you or to cause you grief. As you can see, this is this is a lot of stuff. Some of it we need solely for the purpose of, preparing the petition. Some of it, like pay stubs and tax returns and things like that, we're going to need to turn over to the trustee at some point, so that he can verify what we've said in our petition. So how hard is it to do this? I'll tell you, the hardest part of this is the preparation phase. Filling out the questionnaire, gathering all that paperwork it's a little bit daunting. 52-page questionnaire, it takes some time. You have to go through it. You can't just, throw it, do it in an hour or 2. Or at least you can't do it correctly or well in an hour or 2. once you get all that information, you give it to your attorney, and they will help. They're going to prepare your official paperwork that's going to be filed with the court. The hardest thing for you after you've given your attorney all that information is probably going to be signing, the petition in the 7 or 8 places that your signature is required. There's a lot of different places to sign, so that's probably going to be the next hardest thing. Once your case is filed, you will be required to meet with the trustee, the person who's going to administer your case. The meeting is actually called the meeting of the creditors. It's called that because creditors have the opportunity to show up to the meeting that you have with the trustee and to ask you questions. The name's a little bit strange because almost 99% of the time, probably more, no one shows up. No creditors appear. It's just you and the trustee. The banks and credit card companies and auto loan places, they don't have time to send people to these things. And the only time they might have some attorney appear is if they think there's fraud. So like I said, the trustee actually, part of his job is to represent the creditors and manage your assets and things so that no one gets left out and no one gets messed over. Like I said, the meeting typically now, they're holding them by telephone because of the pandemic, the COVID pandemic, and these meetings aren't very long. Typically, the trustee has some very standard questions he'll ask, and the other, if he finds some information in your petition that he has questions about, he may ask you a couple specific questions about that. But other than, most of the time, as long as you've been honest and your attorney's filled out the petition correctly and fully, you're probably going to be, I think 10 minutes average might be actually a little bit of an overstatement. I've had some last, 3 minutes. It's very fast sometimes. And I've also had some last half an hour. So it's going to vary depending on what you have and what your circumstances are. Okay. Now, what does it cost to file a bankruptcy? Well, there are 4 main costs when you want to file a bankruptcy. The first, and probably the most expensive, obviously, is an attorney. Like I previously said, the attorney's fees are going to depend on who you choose, and typically they range from 0, like if you qualify for free legal assistance, or they can go anywhere up to $2,500, or more, I guess, depending on what the market will bear for your case. So that's going to be possibly the biggest expense. There's also a filing fee besides the attorney's fee. This is paid to the court, and what it does is it helps pay for running the system, the court system. Currently, for a Chapter 7, the filing fee is $338. It went up $3 January 1st. And if you are extremely low income, there is a possibility that you could get a fee waiver. And if your fee waiver is denied, they will also work with the court may agree to let you make payments to them. Typically, you can request it straight off the bat. You can request a waiver, or you can request to file, to pay in payments. Typically, if the court rejects your fee waiver, that they won't let you file for free, they'll issue you a payment plan so that you can pay it off in three different payments. The next cost is going to be bankruptcy education classes. When you file a bankruptcy, you're required to take 2 financial education courses during the course of the bankruptcy. One is a pre-filing class that you take prior to filing your bankruptcy, When you take these classes, once you're complete, they give you a certificate, and your certificate is filed with the court along with your petition at the beginning. The second class is taken after you filed your petition and you have your case number and the case is on its way. They're basically financial responsibility and managing money and budgeting is what the gist of the cases, the classes are, I'm sorry. And those classes do cost. They're run by private companies. There's a lot of them out there, and depending on which provider you select, generally the prices range from anywhere around $20 to up to $50 for each class. They do provide the classes in Spanish and English, and you can take them online on a computer or you can take them on a telephone. If you are a low-income person, again, you might be able to apply. You can apply for a fee waiver with most of these companies, and they'll tell you if you qualify or not. There's one final cost that may come up, and that is additional filing fees. If you have to amend your bankruptcy petition after you file it initially, say you forgot a creditor, say somebody mailed you a $10,000 medical bill after you'd already filed, but the treatment came before your bankruptcy, then we might, it's worth the $32 that you have to pay to amend to put that creditor in that you owe $10,000 to. Because if you have debt and you do not list the creditor in the bankruptcy, the debt isn't necessarily gone. You have to provide them notice that you're filing bankruptcy, and you have to give them an opportunity to object. And if you don't do that and you don't list them and they don't know, nothing, the debt doesn't go away. So how long does it take? How long does this process take? Well, it is a process, and there is a timeline for Chapter 7. My finding is that the preparation and the getting the questionnaire back and the course done, and that the lead up to the actual filing of the bankruptcy case is the hardest and longest part. There are clients who I'm not sure what happens to them. They fall off the planet or what they do, but they come to your office and they talk to you and they're like, yeah, I want to file a bankruptcy. I need it. And then you give them the questionnaire and say, call us when you're ready to come back in and talk about the questionnaire. Never see them again. Or you see them 7, 9 months, a year later. So that to me is the longest part of the process, is actually normally that. Because once we have the petition filed and you've taken the class, the petition is filed electronically and happens with the push of a button on a computer. So it's rather quick. Then the next thing is about a week after you've actually filed, maybe a little less depending on how busy the clerk is, you'll get a notice. We'll get a notice that says you have a meeting with the trustee, and it gives you a time and a date that you'll meet with the trustee. And normally the meeting is somewhere about a month after the day you file, roughly a month, 5 weeks, somewhere in there. In our area, in Naples and Fort Myers, just so you know, if you're interested in filing, at the current time, the trustees only conduct meetings on Tuesdays. Kind of a weird day, but they conduct meetings all day on Tuesdays for Chapter 7s. And once you get to that meeting with the trustee, and you've gotten through it, he's asked you his questions, and everything's good with him. There's a 60-day period after the day that he concludes the meeting that creditors have, and the trustee has, to object to your case or your discharge of all your debts. However, if no one objects and depending on the circumstances, it's kind of rare that there's a lot of, it's rarer that there's objections than there are objections. I mean, there barely, I haven't seen a lot of objections, but if there are no objections, roughly after the 60 days, are passed, maybe a couple days extra, depending, the court will issue a discharge of your debts. And if and typically your case can close on that day, when they discharge your debts. So, but if a creditor or trustee file an objection, your case is going to remain open a lot longer. We have to deal with the objection, which usually means that you will actually get to see a bankruptcy judge. Maybe, maybe not. It just depends on if we can work it out before it gets that far. If you have a lot of assets and you can be, forced to you can be forced to repurchase them or surrender them to the trustee. And if that happens, your case is going to remain over until the trustee has administered the assets and dispersed any money that he gets from your assets. And you will still get your discharge after the 60 days, but your case won't close until all the financial aspects of the trust that the trustee has to do are done. If your case goes like clockwork, and there's a little clock over there, it could be done in about 3 to 4 months after the date of filing. Typically, that's the range, 3 to 4 months if everything's smooth and there's no repayment issues. So now we're talking about repayment or my stuff, and this is, are they going to take my stuff? The biggest worry is people say, am I gonna lose all of my stuff? Well, the answer is no, you're not gonna lose all of your stuff. Now, it is possible that you could be forced to either give up property and turn it over to the trustee, or the trustee can give you the option to basically repurchase the item based on the value and pay the trustee for that item. And then he would use that money to, pay creditors and pay for administration of your case. However, this is how it works. In the bankruptcy code, there are provisions that allow someone filing bankruptcy to keep a certain amount of property. And the bankruptcy code allows you, and what they do is they call it exempt property. So you can keep certain property away from your creditors. And there are some different categories of property, and certain things are exempt. So the bankruptcy code also sets out what are called the federal exemptions. The exemptions are a list of things that you can protect from creditors. They provide a dollar amount of value that you can protect, and they fall into certain categories like household goods or a vehicle or retirement account or things like that. There's many different categories of things, and there's many different exemptions. And but the federal system, when bankruptcy law was written, there's a federal exemption, and it lays it out, and it keeps them, that's what protects your property. Now, most states also have their own set of bankruptcy exemptions, and the state exemptions vary quite a bit from what the federal exemptions are. And the state exemptions vary depending on what state you live in. I've seen in some, states where they specifically wrote in that you can keep one Bible, and you can keep a wood-burning stove. And this stuff is still on the books. I know that it doesn't seem, like a wood-burning stove doesn't seem to us in Florida, or, that doesn't seem like a big deal, but maybe it is if you live in Maine or northern Minnesota or somewhere like that. But they vary, pretty widely from state to state. Some of the agricultural states provide livestock can be exempt. Some of the states give their residents the choice of whether they want to use the federal exemptions or the state exemptions. Just so you know, Florida is not one of those states. Florida residents have access to only the Florida state exemptions. So what are the Florida state exemptions? Well, if you're married, I'm going to go through them, but if you're married, you get to double the number if you're filing jointly, if you're filing as a couple. If you're filing just by yourself, you're still stuck with only the one single number if you're married. Your house, if you own a house, basically your house is protected. There's nobody going to take your house shy of a foreclosure, which can still happen, but no other creditor other than someone who has ties to your house is going to take it. So your credit card company is never going to get it, things like that. So your homestead house is protected almost with basically an unlimited number, amount of a dollar amount. In Florida, household goods are exempt up to $1,000. Household goods are your furniture, your clothes, anything in your house, basically. However, it also can include stuff like your money in the bank. So $1,000 can be pretty tight. The Florida exemptions also include $1,000 that you can put towards the equity in a vehicle. Now, when I say equity, it's the amount, of the vehicle that you own free of any loans. So if I had a $10,000 vehicle and I had a $9,000 loan, I would only have $1,000 worth of equity because 10,000 minus 9,000 is 1,000. So I only have value of about $1,000 in that car because I still owe somebody, 9,000. But that's how you would use your vehicle equity. If you do not own a house, they are generous and they provide what's called a wild card exemption, and it's $4,000. And the wild card can be used in any of these other categories. So like if say you had a car that was worth, after everything, it's worth $4,000 and you can only use this 1,000, so there's still 3,000 that you don't have protected. You can swoop in with this 4,000, use 3,000 of it and, protect your car. So that's a good thing to have, the 4,000, just crazy. But again, it's only if you do not own a home. I kind of makes me laugh because basically they're saying you only get $4,000 if you don't own a home. But I could have $1 million home and get it all exempted. But if I didn't, I only get 4,000. Seems a little crazy, but I guess it's better than nothing. Other things that are exempt include like 401k, retirement accounts, most retirement accounts, pensions, annuities, and they're unlimited amounts. So, these things, for the most part, all of these retirement things, there are some that do not qualify, but most retirements are unlimited. Life insurance proceeds, if someone dies, then that's protected money. Personal injury awards, they're protected. Disability benefits, unemployment benefits, Social Security benefits, workers' comp benefits, veterans benefits, they're all protected. And there are many, many more small, exemptions that apply very specifically to certain people. So I'm not going to list them all, but the majority, the most important ones, to be honest with you, are the first four, or the first few here: the homestead, the household goods, the equity in a vehicle, and the wild card. Because these are the ones that most people end up dealing with, especially in Chapter 7 cases for the most part. A lot of people don't have the rest of the stuff. So that's what we've been looking at. So what does this mean, and how do I actually protect my stuff? Well, when you fill out your petition, you are required to list all of your property and you have to give it a value. Typically, we tell people that to value it as if it was at a yard sale, but be realistic. Your couch is not a quarter unless there's some major problems with it. So you have to be realistic about it. And in your petition, then you can designate what you want to protect. And your attorney will, apply the proper exemption to use when he goes through all of your property. So for a lot of debtors, they're going to have more than enough exemption space to protect all of their property. And this is great as you get to keep everything. So it's not a big deal. But what happens if I don't have enough exemption space for all my stuff? Just because you leave something unprotected or unexempt doesn't mean you're going to lose it. If you have unexempt, the trustee, will basically say, hey, you have $1,000 worth of property that's over your exemption limit. Now, do you want that property? Because if you do, I will sell it back to you for $1,000, and I will allow you to break that up into payments over 12 months. So, you can keep it and you pay the trustee, and that money goes to, the trustee and your creditors. Or if you say, I don't really like my couch, take it, you can give it to the trustee, and he takes whatever the couch is worth off of your total, and hopefully then you're underneath the limit. And what he does with it is he sells it at an auction. And he uses the money to administer your case and, split between the creditors. And, if you do either of those two things, like I said, he's going to take the money and he's going to, give it to the creditors and himself to pay for costs of, taking care of your case. I will say that you have the option to do both of those. Say there's, $1,000 worth of property that he lists, and say you wanted to keep one of the items, which was, $300. So you could keep that one and give him the rest and pay him $300, and he would still break it up for you. But you have the option to do both. So in the situation where if you're going to do the repurchase, or he's got an auction, you're still going to get your discharge after 60 days after your meeting with him, but your case is going to remain open until he deals with all the money and getting it out to creditors and files his financial reporting to the bankruptcy court. So that's, your case isn't going to be lickety split over. I want to give you a few words of warning. The trustee has the authority to request an appraisal of your household goods. So if he thinks that the numbers on your petition don't look good, don't look right, don't look plausible, he can hire out of his own pocket an appraiser, and they will call you and set an appointment and come out and look at your stuff. And they're not going to dig through every drawer, but they're going to walk through your house and look at the major items, and they're going to have a copy of what you listed on your petition, and they're going to go through and they're going to value it. And if they see something that's not on there, they're going to value it too. And they're going to report back to the trustee. If your exempt property is extremely close to the maximum limit or over, the trustee is probably going to hire the appraiser to come and look over your property and value it, because one of the trustee's jobs is to get as much, I hate to say it this way, but to get as much money from you as he can legally. So, you have to, and his job is to protect the interest of the creditor. So if you have property that you're not claiming and it's not exempt, it's subject to being taken. So the trustee will use the appraiser's values over your values when calculating the value of any property for exemption purposes. So if you say in your petition your couch is $50 and she comes in and says your couch is $75, the couch is $75. Now, if it comes to cars, and he's going to, when you value a car for the purpose of bankruptcies, The court allows the trustee to use the NADA clean retail value of the car. This is the most unrealistic number on the chart. It's ridiculously high. It's as if your car was in perfect condition, even though it's not probably, and sitting on a showroom floor. So it goes a little, it's ridiculous. So what we tell most people is, if you have equity in your car and it's over that $1,000 and you don't have a wild card to help you pay, to keep the price down, you might want to take it to one of the court-appointed appraisers and get it appraised. Now, court-approved appraisers, I'm sorry, not appointed, approved, to get the value, an accurate value. Typically, they're going to look at your car as if it's your car, and if it has a scratch, they're going to note that. If it has bad tires, they're going to note that. If it has a bad engine, they're going to note that. If it needs brakes, they're going to note that. So, the trustee will, if you give him an appraisal for the car, he's going to take it if it's from one of those court-appointed, or court-approved, I'm sorry, not appointed, court-approved appraisers. It's almost always in your interest, if you have equity and you're over your limits, you almost have to get it appraised, because it does cost. I think it's somewhere between $75 and $100, depending on who you go to around here. But it's going to be worth your while probably in the end. So continuing on, I'm going to just give you some examples. Now, we have Joe, and he owns the following items. He owns furniture, $500. He has $1,000 in his bank, and he has a car that's worth $15,000, but it has a loan for $14,000. So really, he only has $1,000 in equity in the car. Can Joe exempt all of his property? Well, yes, Joe can exempt all of his property. And that doesn't show up very well. What Joe has, he has enough. So Joe's exemptions, he has $1,000 from the state. The state exemption says you have $1,000. So he has $1,000 worth of his vehicle. He can protect it because it's only worth $1,000. Joe can use his $1,000 household good exemption to either cover his bank account or cover the furniture and half the bank account. And he has a wild card of $4,000. So he has $4,000 to spend, or $5,000 to spend, but only, but only $1,500 to save. So he's got money he's got room to spare. Okay, so here's Joe again, in example number 2. Now Joe owns a home over here. It's $250,000. He has furniture. It's $1,000 because he has more house. He has more furniture because he has a house. He has a bank account with less money in it because he has a house, and he still has the same old car with $1,000 equity. So we still have $1,500 worth of assets here. They changed around a little bit. But can Joe exempt all of his property now? And the answer to this one is no, he cannot. Because Joe can exempt his home without any problem because he has unlimited access or unlimited value. He can exempt his car without any problem because he has $1,000 and it's only $1,000. But the problem is he has $1,500 here now, $1,500, and he only has $1,000 household item or household goods exemption. Now, the $1,000 would cover that, but it's going to leave this $500 wide open. Now, there's no wild card because now Joe owns a home. So now Joe has $500 that he's going to have to either, $500 worth of property. He's either going to have to end up paying the trustee or, turning something over worth $500 to the trustee. All right, third and final example, Joe and Jane, his wife, they got married and they own the following stuff, and they're going to file bankruptcy jointly. They have the house, they have the car, they have the couch, the furniture. They have $1,000 in the account. They have Joe's car still with $1,000 equity. They have Jane's car here, when also has $1,000 equity. Now, can Joe and Jane exempt all of their property? Well, the answer here is yes, they can, because their house is protected. No one's going to touch it. Joe has $1,000. He can take care of his car. Jane has $1,000. She can take care of her car. Joe can use his $1,000 worth of household goods on the furniture, say. Jane could use the other her $1,000 because now they get double. Don't forget, they get double because they're filing jointly. So they each get the $1,000 and they're safe. Everything is covered. So that's how basically exemptions and keeping your property works. So are there any consequences for bankruptcy in the future? Well, yes, filing bankruptcy does have consequences. And you kind of have to weigh the consequences against the benefits that you're going to get. Is getting rid of all the money, all the debt that you have, most of it worth this, these consequences. So a bankruptcy, a Chapter 7 bankruptcy, is going to stay on your credit report for 10 years. It's just going to sit there. There's no getting rid of it, unless there's somehow it's on there in error. But most people who file bankruptcy, it's not an error. So it's going to sit there. And bankruptcy on your credit report, it's going to depress your score some. But you also have to look at if you have, 10 accounts that are overdue and, paid a history of late payments, is bankruptcy any worse than that? So that's kind of a trade-off. Overall, people have told me that after bankruptcy, their credit scores, they tend to rise back up fairly quickly. Maybe, probably a lot more quickly than if they did nothing or even tried to pay off that debt, because they would be doing it at a very slow pace. There's obviously, if your credit score goes down, credit's going to be more difficult to obtain for a period of time. And if you do get it, you're going to pay higher interest rates. Almost no way around that one. And if you're looking to try to buy a house in the future, in the next few years, you're probably going to have a difficult time getting a mortgage for 2, 3, 4 years with a bankruptcy sitting on your credit report. A bankruptcy could affect employment opportunities. Certain jobs might not be open to someone with a bankruptcy. I don't have specifics, but I know that some security clearance jobs, if you have a bankruptcy, you may not be able to pass the security clearance. I know some financial industry jobs are difficult to obtain if you have a bankruptcy. So that's a consideration. I don't think the average job is like that, but that is a possibility. Bankruptcy filings are also public records. They're court records. They're available to the public. It's not easy to access them really, but they are accessible. And you'll notice that, if you file bankruptcy, you'll get mailings from companies that want to help you, credit card companies that are looking to, give you secured credit cards or something like that. There are people who do search the records, and it is going to be there. So, like any other court case, and bankruptcy can negatively affect your ability to find rental housing. Also, landlords, they're going to, if they do some kind of background check or credit check, they're going to see it, and it's going to be a concern for them. It doesn't mean that you're not going to get the house, but it just could be more difficult. So that is what I see as a problem in problem, and those issues are there, and that's really the end of my presentation. I'd like to thank you guys for all attending. The Community Foundation, these are thank you, and these are partners or agencies that help fund legal aid and help fund our project. I work in what's called the Consumer and Housing Unit, and the Community Foundation of Collier County, the Collier Comes Together Fund, the Department of Treasury, the U.S. Department of Treasury, the Florida Division of Emergency Management, Collier County Community and Human Services Division, and the United Way of Collier County and the Keys. These people are all integral partners with us in providing funding for different programs and keeping us, giving us the ability to do what we do. So I just wanted to give them a shout out and thank them for their support. And I'm not sure if there's any questions, if anybody wants to ask anything. But other than that, I'm done with my presentation. And I hope it was informative and helpful.